Well, thank you. Vice Chairman Quarles, Comptroller Otting, and Chairwoman McWilliams, thank you all for your interagency response to my letter. I've never seen such a timely interagency response, and I am grateful for that. And the clarity you gave me and the questions I outlined, I appreciate. And as a matter of congressional oversight of the implementation of public laws, that ongoing process is the assurance that we will have faithful implementation of our laws in a way that is conforming with congressional intent. And you outlined in your responses, there are a number of comment periods that have closed. But I also know there's a significant amount of work to be done on your part and your staff. What I've heard around town is there are bandwidth issues, which is, we don't have the capacity to get these things done. It's a lot of work. Then I look back at the Obama administration, I never heard complaints about bandwidth issues. And there are a lot more regs to implement then. And so I just want to ask you, do you currently have within your capacity the staff, the necessary ingredients to get these rules enacted in a timely fashion? Vice Chairman Quarles, and I'll ask you, Mr. Otting and Ms. McWilliams.
Yes, yes, we do. We are, as I think we indicated in response to our letter, the bulk of the core proposal, which came out last October, was. We don't keep detailed records of this, but I feel quite confident in saying that that was the fastest proposal of an implementing regulation of a major congressional action in the history of the Federal Reserve, certainly in the modern history of the Federal Reserve.
We had 10 years to prepare, so that helps.
And we are on track to complete the implementing actions for S-2155, have the bulk of the implementing actions completed by the third quarter of this year, and all of them completed by the end of this year.
Thank you. Mr. Otting.
Yeah, I think there's been a tremendous amount of communication. We also divided the rules. The common process is one of the agencies will take a lead on a particular rule, so we've divided these rules, so call having the pen. But I would also say probably what has worked effectively is the three of us speak almost every week, and any items that are outstanding on 2155, we bring them right to the top. All of us pretty much probably carry in our briefcase the matrix of where we were, so we are acutely aware of the necessity to move those rules through the process. And I actually think we've had good cooperation and have had no bandwidth issues as we've tried to move both this and some other legislation forward.
The FDIC has highly capable staff that will complete the rulemakings in due time, and we work very well with our partner agencies.
That's good. So, to you, Ms. McWilliams, and you, Mr. Otting, there's the ongoing question in the Madden versus Midland case of the question of valid when made. And my question to both of you is, will you commit to providing clarity to banks and non-bank third parties as it relates to the foundational legal principle of valid when made? Mr. Otting?
Well, first of all, we do think that was an inaccurate conclusion in that case. We had hoped for perhaps some legislative fixes to that, but it does appear now we'll have to have some regulatory fixes to that, and we've begun the discussions within the agency.
And the issue of federal versus state law in banking cases is not new. What's new is that it comes at the time of great innovation that could stifle entrepreneurship and progress in how banks are able to conduct business. So we're currently examining at the FDIC the appropriate role of the agency as this case unfolds.
Well, time's ticking, and I'll follow up with both of you on that. Mr. Quarles, I'll have a number of questions for the record about the switch from LIBOR to SOFR. The concern here is the disruption in the marketplace. Is that a concern you share in this shift from, LIBOR to this new benchmark standard?
It is. I think, I mean, that's the reason that we began catalyzing the private sector response to this, really beginning 7 years ago. The Federal Reserve was indicating that this needed to be done. I think as people think about the LIBOR transition question, it is important to remember that this is not a result of regulatory action. We are not mandating the transition from LIBOR. We're recognizing that private sector banks that are responsible for determining LIBOR will no longer do so after, or certainly very well may no longer do so after a period.
I'll submit more questions for the record on LIBOR versus so forth.
Thank you. The gentlewoman from New York, Ms. Velasquez.